All right, shalom again, friends, to another webinar that's being co-sponsored by our partners of old and also the Center for Women's Justice, whose founder and director, Dr. Susan Weiss, will be our speaker tonight. So this webinar is brought to you by Chidush, by Ruach Chidush, Rabbis and Cantors for Religious Freedom and Equality in Israel, and it's wonderful to have quite a number of colleagues on the call. J-Plan, the Jewish Pluralism Legal Action Network, and at this point with 50 participants, I'm not sure who of J-Plan is on the call, but Peter Buxbaum, our co-chair, is certainly on, and I assume others are as well. And the American Association of Jewish Lawyers and Jurists. Tonight's webinar is an area that obviously has been of interest to our speaker and to me, but has been on the mind of many Israelis. And I think it's extremely important to share the awareness of some of the challenges faced by Israel, by women in Israel, in this area that involves everything. It involves Judaism, it involves law, it involves status of women, it involves equality, it involves new immigrants, and more, as you will hear from our speaker tonight. So Dr. Susan Weiss, as I said, the founder, director of the Center for Women's Justice, is known to many of you and to many around Israel and the world as a fierce advocate for justice and equality for women in her capacity as an attorney and as a scholar and as an activist. And it's wonderful to have her share with us an analysis from the legal battlefield. And no better testimony than the one that Susan can provide us on the topic of Israeli courts versus converts, Mamzerim, adulterous women, and immigrants. Go ahead, Susan. The microphone is yours.
Okay. Thank you, Uri, for the wonderful introduction. I hope I will live up to your words, and thank you everybody for coming. Okay, why is this not moving? The catalyst for this discussion today is a case that the Center for Women's Justice is now handling in the Supreme Court. And it's a case of a woman who, an immigrant from the former Soviet Union, who came here 30 years ago, and had her status as a Jew revoked after 30 years and 4 confirmations. What happened? I will be telling you about this case later, so I don't think I will belabor it right now. But over the 30 years, her daughter's Jewish status was confirmed. Her two daughters' Jewish status was confirmed. And when one of the daughters went to get divorced, her husband said, "Oh, by the way, you know, my wife is not Jewish." They opened up the whole investigation into the Jewish status once again and deemed the whole family and the grandchildren not Jewish. And this is a petition in front of the Supreme Court that the Center for Women's Justice is now handling, and it was the catalyst for this discussion. Oh, it's going this way. Okay, I see. Okay, the outline of my discussion today is as follows. I will give an introduction, a general introduction about the Center for Women's Justice and about Israel, what I call Israel's partial theocracy. Then I will present my thesis. My thesis is that what's happening in the rabbinic courts today is an Inquisition. My thesis is that you take a theocracy, a carve out from the democratic regime that we have here in Israel, and you use overreaching regulations, and the result of that is an inquisition. In order to prove my thesis, I will briefly explain to you what these theocratic laws are, which is the marriage and divorce law and the chief rabbinate law. Then I will discuss these overreaching regulations, which have to do with Mamzer, converts, suspected adulteresses, and immigrants. I hope I get to all of them. And underneath each of these rubrics, I will present the regulation. Most importantly, I will bring protocols from the rabbinic courts in which I will show how the state is infringing, the state rabbinic judges are infringing on the privacy and dignity of Israeli citizens. And then I will show the Supreme Court's response to these infringements, which is basically to pass regulations or to defer to regulations. And my bottom line of my discussion is that I'm accusing not the rabbinic courts, but the Supreme Courts, because the Supreme Court could have limited the rabbinic jurisdictional reach and did not. So that is the outline of my discussion. And I will
just before you move on, Susan, one other sort of organizing comment, and that is, you see that there is a lot of interesting and challenging stuff that we are going to be presented with. Don't hesitate to use the chat to write your questions, and at a certain point, I will look at them and present them to Susan. So this is going to be at least partially interactive. Use the chat, send in your questions.
Okay, thank you very much, Rory. Okay, so here is the introductory part. And here I'm just showing you a picture of the Center for Women's Justice. It's not all of us, but it's most of us. I'm there on the left. There's Nitzan Kaspi-Shiloni, Rachel Stommel, Michelle, Shoni, I think Shoni's on the line, and Adiya. Adiya is another attorney. Rivka Lubitch is also part of the Center for Women's Justice. And we're a small, not-for-profit feminist law firm working to try and do systemic change in Israel whenever church and state clash. So the problem that we deal with in the Center for Women's Justice is the partial theocracy that the Israeli state has carved out that infringes on women's liberties, irrespective of their religious beliefs. And the way that I like to summarize this whenever I give a discussion on it is, in Israel, a woman can be a fighter pilot, but she can't get divorced. In other words, in some ways, we're very, very progressive. And in other ways, and particularly in the area of marriage and divorce, although also in other areas, as whenever, in particular in other areas, and in particular when the state rabbinic establishments are involved, the rights of women are infringed on. So let me go, and I'm going to go into this a little bit more. In Israel, all the matters of marriage and divorce, a person cannot get married and cannot get divorced except in accordance with Orthodox law, Orthodox Din Torah law. So it doesn't really matter if you are religious, if you believe in God, if you're conservative, if you're Reform, if you're Orthodox. If you are Jewish, the only person you can marry in Israel is another Jew. And you can only get married in accordance with the Din Torah Orthodox laws, and you can only get divorced in accordance with Din Torah Orthodox laws. This is a system that we inherited from the Turks. It's called the millet system. And one could argue that it was a system that is to some extent multicultural because it lets each culture determine the personal status of its constituents. However, as you will see, because there's no separation of church and state in Israel, this millet system infringes on the civil liberties of Israeli citizens. So it's different. The infringement is slightly different for all the different millets. There are different rules for Catholics. There are different rules for Muslims. There are different rules for Jews. There are different rules for Druze. The Druze actually have some very progressive rules. And what I'm going to be discussing today is the rules for Jews. So Jewish women, and part of the problem, Jewish law, Din Torah law, right now, halakha, is that Jewish women can't get divorced without their husband's permission. This means that women can be held forever in marital captivity and are subject to extortion. In other words, they have to often pay for their freedoms. This is the problem of the aguna. I will not be discussing the problem of the aguna today. But it's a problem of the aguna that is actually, I think, the root problem of the other problems that we're going to be discussing. So the other problems, the problems that we're going to be discussing today is that the Din Torah rule is that a woman suspected of adultery cannot remarry her husband or lover after divorce. That's a Din Torah rule. In other words, if you left your husband because your marriage was breaking down and established a relationship with another person, if the rabbis know of that relationship and then you want to marry your new partner after the divorce, Israeli law won't let you do it. And Israeli law won't let you remarry your husband either. If you had a child with that new partner, that child is called a Mamzer. The state will blacklist that child, and a Mamzer cannot marry another kosher Jew. A Mamzer can marry only another Mamzer or a convert. And as a result of the millet system, and a result of the fact that there's no intermarriage in Israel, only persons of the same millet can marry the person of his millet, of his or her millet. Jews can only marry Jews. So as a result of that, when someone comes in front of the rabbinic courts or the marriage registrars and asks to marry, they have to examine if you're really Jewish. And they also have, and if you're a convert, they have to examine, or they feel they have to examine, the authenticity of your conversion. And that's the root of the problems that we're going to be discussing today. So the millet system infringes on civil liberties in many ways. The basic right to marry, the basic right to freedom of religion and freedom of conscience. But what we're going to be discussing today mostly is the infringements on dignity and the infringements on privacy. So the vision of the Center for Women's Justice is civil liberty for Jewish women in Israel. We feel that everybody is entitled to their own religious conscience, but that the state should not be coercing or forcing people to adhere to halakha as interpreted by the rabbis or as interpreted by anyone. Okay, so here I'm going to be discussing the Inquisition. And as I said, my thesis is that a theocracy plus overreaching secondary legislation results in the Inquisition. And as I also already said, severe infringements on the right to marriage, religious freedom, plus infringements on privacy, dignity, and liberty. And the person, and the finger that I'm pointing at is at the Supreme Court. Theocratic laws. The regulations theoretically have to be based on laws. They can't be just written out of whole cloth. So the laws that form the basis of the regulations that I'm going to be discussing this evening is the Rabbinic Court's Jurisdiction Marriage and Divorce Law of 1953 and the Chief Rabbinate Law, the Chief Rabbinate of Israel Law of 1980. The Section 2 of the Rabbinic Court's Jurisdiction Law is that marriage and divorce in the state of Israel shall be arranged in accordance with Din Torah. That means civil law does not apply, only the rules of the Torah when it comes to marriage and divorce. And as I said, it doesn't matter if you believe in God or not, or if or of what denomination you are. Orthodox law will determine if you're married or divorced, which means that if the husband doesn't want to give a get, if the husband doesn't want to agree to the religious divorce, the woman stays married. The Chief Rabbinate of Israel law is very important too. It's very broad. And if you're looking for something substance, you're not really going to find it here. But but the rabbis call on this law to justify a lot of their regulations and actions. And this law says the functions of the Council of Chief Rabbinate are activities aiming at bringing the public closer to the values of Torah, religious learning and mitzvot, religious duties. And in order to carry out that function, they can do any act required for the carrying out of its function under any law. So it's a very, very, very broad law. The regulations. The first regulation that we're going to talk to is Mamzer. On this slide, I brought the clause, the sentence, I'm sorry, in the Torah on which they base the rule of Mamzer. I'm not going to go into a lot of the exegesis on this, but it is the basis on which they say that any illicit kinship relations based on Leviticus result in a Mamzer. For the purposes of this discussion, I will be referring only to a child born out of not out of wedlock, out of the marriage. In other words, in Israel, a child born out of wedlock is not a Mamzer, but a child born of a relation to a married woman with a man who's not her husband will be considered a Mamzer. And a child born who is considered a Mamzer, as I said, cannot marry any kosher Jew. And this is a stigma that the state keeps a list of Mamzerim like this. And the Mamzer is forever. In other words, it says for 10 generations, but in fact that means forever. Any child of the Mamzer, grandchild, great-grandchild, is always stigmatized. So believe it or not, there were no Mamzer regulations until 2003. They were promulgated by Eliakim Rubinstein. It's procedural regulations regarding matters of legitimate lineage. It doesn't use the word Mamzer in the title of the regulations. It says, should a rabbinic court surmise during a hearing relating to the matter that it has no choice and that it must, from a halachic din Torah perspective, examine the facts that have come to its attention regarding the lineage of a person, the court will order the opening of a separate file to investigate the issue. In other words, broad discretion is given to the rabbinic courts whenever they suspect that a Mamzer may be in front of them. So here, and this is what I feel one of the most important parts of this discussion, is an examination that occurred in 2012 to one of our clients. She was in front of the court because because she wanted permission to marry and she had a child under the age of 2. There's another regulation, which I haven't brought here, that any woman who wants to marry who has a child under the age of 2 has to get special permission from the court to marry because of a rule in the Shulchan Aruch. In any event, the court says, were you together with your husband after the separation? They're trying to understand if she had sex with her husband after she left him. Our client says, well, we broke up in this date and the child was born on this date, more than a year after the breakup. I have not found out and now she's explaining to the court who she thinks the father of the child is. I have not found out the identity of the men who were with me at the club. There were a few. I know one was not circumcised and the other had a tattoo and a cross. They were Russians, but I have no information about them and I cannot find them. Even if I saw them, I would not recognize them. It was a one-time fling. When were you with your husband for the last time? It's hard for me to say. Did you have sexual relations after your divorce? I did. And as you see, they brought in her ex-husband also to cross-examine him as to whether or not he had sexual relations with his wife and could possibly be the father of the child, and then the child would not be a Mamzer. But the ex-husband wants absolutely nothing to do. They have a very acrimonious relationship. And she said, I severed all connections with wife and we did not have sexual relations even after a few months before we separated. In other words, what I want you to see here is this examination of a woman's sexual activity, and in her desperation, she's trying to tell the court that she had an orgy with a few men who were probably not Jewish, and therefore, if the child is born out of the marital relationship, but as a result of a relationship with a non-Jew, the child is not a mamzer. So this is an example of what happened in the court. Now, we brought 2 cases for women like this to the Supreme Court. And what we argued was that the Rabbinic court had no jurisdiction over children, because as I showed you, Rabbinic courts have jurisdiction over people who want to marry and divorce, and by definition, children do not want to marry and divorce. So we argued that they had no jurisdiction over these children and no reason to have passed these regulations. These regulations were extra jurisdictional. What happened in these cases is that the court remanded both of these cases back to the Rabbinic courts. The Rabbinic courts did not want this whole regulations thrown out. So they conveniently figured out how to make the 2 children in these cases kosher again. And the court was very happy. They deemed the cases now theoretical because the kids were kosher, and refused to look at our case or the arguments that we made against the regulations. Okay, converts. There's there's nothing in the Torah really about converts except the obligation to love the convert, or to love actually the stranger who resides with you, the stranger, the ger. You shall love him as yourself, for you are a stranger in the land of Egypt. I'm not going to go into this this slide. In this slide, I brought what I think are 4 very interesting academic analysis of the issue of convert and how it's a social construction that changed over time. Sometimes converts were required sometimes they didn't want converts at all. And then at a certain point in time allowed converts to enter into the Jewish people if they accepted certain religious practices. And then the question was how much religious practices they had to accept. But one thing I think I can say is that you're not supposed to question a convert after the person has been converted, or certainly not revoke their conversion. But what happened was, and this is a client of the Center for Women's Justice also, the client went to get divorced. And as I explained to you, Rabbinic courts have exclusive jurisdiction over the issue of marriage and divorce. And theoretically, they should not do a divorce if the person before them is not Jewish. So an Ashdod court decided when they saw this client in front of them and discerned that the client was a convert and didn't look particularly religious to them, asked this client if she went to the mikvah and if she turned the lights on the Sabbath. And when she said that she did not always go to the mikvah and that she did turn on lights on the Sabbath, instead of giving her her certificate of divorce, it was an uncontested divorce, they declared her not Jewish. We appealed this for her in the High Rabbinic Court, and this protocol is a little bit of the discussion of what went on in the Rabbinic courts. And here again, you'll see that they're cross-examining our client about her sexual behavior and about her beliefs. And here the High Rabbinic Court asks her, before the conversion, did you ask yourself why as a Jew you must be observant and keep the commandments while secular Jews do not keep the commandments, do not have to keep the commandments? I think that's a trick question. And the client has, the client answers as follows. I did not want to be a Jew. I had the choice. I think that might be an error actually, but I wanted to convert. I never believed in Jesus or tried to fulfill what he preached.
There's if.
Sorry?
Because it says, if I did not want to be a Jew.
Sorry, right. Sorry, thank you, Tony, thank you. If I did not want to be a Jew, I had the choice not to convert, but I wanted to convert. I never believed in Jesus or tried to fulfill what he preached. I was always searching. Before the conversion, I engaged in sexual relations. In other words, they're saying, or did you have sex with your husband before you got married? I was taught the rules of family purity, implying that she wouldn't be a sincere convert if she had sex before they married, because no good Jew does such a thing. Before the conversion, I engaged in sexual relations. I was taught the laws of family purity. When we began the conversion process, we adhered to all the rules that were demanded of us. We did not live together. We lived with his parents. I feel like I'm living like a Jew, even though I don't keep everything. My son goes to religious kindergarten. I keep kosher all the time. After the wedding, I did not go to the mikveh. We traveled on the Sabbath, but we kept a lot of commandments. I light candles before Shabbat. My husband went to synagogue. We sent the kids to religious school. Here again, we have the state, directly and intimately involved in the religious beliefs and activities and sexual activities of our clients. If you want to read about the whole interrogation of this convert, we actually have it on our website, and it's called The Interrogation of Convert X. I think it's very interesting to see the case. And in this case, the question is that the client had been converted by the state. So under what law or halakha can a state rabbinic court revoke its own conversions? There is no law of conversion, and there was no law allowing them to revoke conversions. So under what basis were they doing that? And that's the question that we presented to the Supreme Court. And what the Supreme Court did was exactly what they did in the Mamzer case. They sent our clients, in this case it was this particular woman and another woman, back to the rabbinic courts for review. And again, the rabbinic courts took the hint from the Supreme Court, reviewed the case, and decided, based on the facts, that there was no reason to revoke the conversion of our clients, and deemed the clients Jewish again. And as a result of that, obviously the court and the Justice Department refused to address the questions that we had raised, the jurisdictional questions raised. And Judge Rubenstein said, from a structural perspective, the situation is not as it was in light of the regulations issued by the president of the rabbinic courts. And here we'll see the regulations. I didn't bring you all the regulations. I obviously couldn't do that. There are now rules of procedure in matters of conversion. These were written approximately at the same time that these cases were being brought by us in front of the Supreme Court and in front of the, appealing it to the High Rabbinic Court. And section 16.1 says, in exceptional cases where the court believes there is room to consider repealing the conversion of a convert, the court may summon the convert to appear before the court. In other words, it's giving the court express permission to review the activities of the convert. And here's something that I just got hot off the presses. It's just from a few months ago. A rabbi sent us this protocol, this decision that he wrote. And in the special conversion court, the mother of a jilted soldier who was seeing a convert went to the special conversion court and tried to convince the court to recall the convert. And this is what our courts are dealing with. And the judge wrote the rabbinic judge wrote a 30-page, a very, very long decision on it. But it opens like this. The convert lived a completely secular lifestyle. She would drive on Sabbath while she was still studying in the program for converts. She would use the phone and defile the Sabbath. Her parents are Christians. She would wear a bathing suit on the Sabbath, and she would have sexual relations while she was having her period. I find, when I read this, I went crazy in the office. I said, why am I paying a state actor, good money, to write a 30-page decision to discuss whether to recall a convert under the basis of these alleged facts. And it didn't really matter to me that in the end, the judge decided that he wasn't going to recall this convert. I think that the very fact that he was even considering these facts is something that the state should not be involved in. Jewish roots. Okay. How do you prove you don't have a sister? That's how there are no rules on proving how to be a Jew. Okay. And if any of us had to prove that we were Jewish, I think to the standards that are now required of immigrants from the former Soviet Union, I think we would have a hard time. So in 2010, and it's largely as a result of the influx of Jews from the former Soviet Union, the rabbinic courts have issued regulations, and here I've brought just some of them for you. So in Section 2, most immigrants are presumed not to be Jewish, and then they have to go prove that they are Jewish. The only people who are not presumed not to be Jewish are Israeli residents who ask for a marriage license and whose parents got married in the country, or immigrants who were married by rabbis recognized outside of Israel by the Orthodox establishment, which is also something that changes all the time. But in any event, immigrants must submit a declaration of particulars in full. And then they have someone which I call a Jewish roots inquisitor, who may appear and testify. They have special experts who both sit in the court and outside the court, and they have a very large, there's also nonprofits that deal with it, mostly from Tzohar, I think. And their job is to inquire into the Jewish roots of the citizens that the court decides they have to investigate. It's not really clear what they look for and what will prove that someone is Jewish. But an inquisitor can reach findings that are not forwarded to persons under investigation, and they may initiate the file in special circumstances and reopen prior decisions indefinitely. Okay. So here, I won't read all of this, but this is just from the Declaration of Particulars, the HCJ Petition. All the things that the person who's under investigation has to bring in front of the court. Names, date of birth, one's parents, brothers, sisters, aunts, uncles, grandparents, great-grandparents, great-uncles, great-aunts, grandparents. You have to attach the ID or passport, the Jewish marriage contract, birth certificates, all court decisions with regard to Jewish roots, family pictures, and they recommend also letters from rabbis, foreign documents of relatives, divorce, death, adoption, paternity, graduation from school, property registration, military service, members in unions or political parties, and any other government documentation. Wow. Okay, and now here's the case. I'm just outlining the facts that I said was the catalyst for this whole discussion. In 1989, a divorced mother immigrated as a Jew from the former Soviet Union. In 1992, she married a Jew. The Tiberias Rabbinic Court deemed her Jewish. In 2013, her second daughter got married. The Ashdod rabbi declared her Jewish. In 2015, the first daughter gets married, and the Ashdod court also declared her Jewish. In 2016, one of the daughters got divorced. The husband threw out the notion that maybe they weren't Jewish. They opened up the whole thing. And in 2016, one rabbi on the court declared mother and grandchildren not Jewish. In 2017, we appealed to the High Rabbinic Court. They decided to transfer it back to the Tiberias Court. And in 2019, the Tiberias Court decided the case without a hearing and based on expert opinion of Jewish root inquisitors. Most of their decision is based on their allegation that there was tampering with the woman's birth certificate. Jewish roots. This is the argument that we brought in front of the court. And we quoted extensively from Lon Fuller on the morality of law, who quotes the Chief Justice of Britain from 1677, a law which a man cannot obey nor act according to it is void and no law, and it is impossible to obey contradictions or act according to them. In other words, what is the burden of proof? Who has the burden of proof? What does someone have to prove in order that they're Jewish? What is probable cause to even question a person if they're Jewish, if they declare that they're Jewish? So these are all the things that we've brought in front of the Supreme Court. And we don't know what will happen because the case is pending and the state has to reply to our petition. Suspected adulteresses. And as I explained to you, a suspected adulteress can't remarry her husband or her lover. This is based on Talmud Bavli, page 5a. And the concept is it's unjust enrichment, that someone who broke her marriage vows should not be rewarded by allowing to marry the lover. That's the logic. The case that we had in the Center for Women's Justice was a woman, a Haredi woman, who was divorced by agreement. And right before the Rabbinic court issued her a get, issued her divorce, the husband whispered to the rabbis that his wife had cheated on him, and they blacklisted her. They said that, that she was a suspected adulteress, and if she wants to get married again, she cannot marry this man who the husband suspected. And we went to court and we argued, is the husband's suspicion enough to put her on the blacklist? Is that due cause based on the husband's allegations alone and subsequent to an uncontested divorce? If there was no reason to investigate the issue of adultery, why can it be raised when it's irrelevant to an uncontested divorce? So in the case here, the same thing happened that happened in the Mamzer case, as I described it to you, and in the conversion case. The court suggested remanding the case to the rabbinic courts so that we review and actually have a trial on whether our client had had sex with this man. Our client refused, claiming there was no evidentiary basis to put her on the list, and that it was subsequent to an uncontested divorce. And besides, she did not want to marry that man. What she was concerned about was she wanted her name cleared because she was a Haredi woman and she had children to marry off, and she didn't want to be blacklisted. And she didn't want to go through an unnecessary trial. And so what the court did in this particular case, there were no regulations. And so what they did was ordered regulations. And I was party to this because I was asked to sit with the Justice Department and the Rabbinic and the advisor to the Rabbinic Court to draft these regulations. I don't think I'm going to go into that either, so that we can leave some more time. But basically, it says that if the court can't do it, if the husband suggests that the wife had an adulterous relationship, the court is allowed to put that, to note that, and the client and the woman is entitled to a full trial if she wants to remarry the man, or if she wants to have it immediately, she can have a full trial immediately. I did not agree to these. Regulations, and the court declared that they were temporary, but they're enforced. And here is what happens. And I brought a case from 2000 of a woman who got divorced in 2017, and in 2020 came to the court. And this is not our client. So this is just, I got right straight from a rabbinic court decision that was actually published by the rabbinic courts. And as you'll see, they bring in the ex-husband, and the woman pleads with the rabbinic court. says she wasn't okay because the ex-husband did catch her doing something, and begs for permission to marry. So the ex-husband says, I once caught them. I checked GPS of the car and located it in the rose garden in a quiet place. They were there together for half an hour. I watched the car for half an hour. I could not see well because it was dark. After some time, I saw that she had opened the car light, and I saw that the back of the seat was down, and I saw her head. I could not see if she was wearing clothes. I saw her head, and I saw him lying on the seat next to the driver, and she was sitting on the seat itself on top of him. I could see him completely. I went there and yelled, and then they left the car. They came out with their clothes on. The woman, I heard what my ex-husband said. I am not justifying what we did. We are not proud of what we did. We know we are not okay, but as I told you, we had a friendly relationship at work. We went out a few times, twice or three times. We hugged and kissed a couple of times. This happened outside of work a few times. Once we went to a restaurant. Once we went to the Rose Garden. The place was not dark. They told us that the light was bothering them, so we closed the light. I sat in the seat next to the driver. The husband sent out a detective, caught her at the Rose Garden, did not catch her in the actual act of sexual intercourse, but it was suspicious. And this is what our rabbis are dealing, this is what our rabbinical judges are dealing with. It is a terrible infringement on the privacy and dignity of Israeli citizens. The woman, who I understand is religious, is desperate to marry this man. And what happened in this case is they did not allow her to marry him. They said that although they could not prove the actual sexual relations, it was a disgusting act, and they did not let her marry. And now I am here with what I call bonus material. I actually have written an article about this, which goes into this in greater depth with a lot more protocols.
Maybe before we go into the bonus, maybe I'll share with you a few of the questions.
Okay.
And it'll give you a chance to sort of change pace and change course.
Okay.
So we got quite a number of questions. The first one is about the title. Intriguing title, but isn't it a bit sexist and unfair to refer to adulterous women? Are cheating men excluded? Doesn't it take two to tango? A proverbial adage everyone is familiar. Just asking.
Okay.
So there were, I think, more questions or comments about the adulterous women. Do you want to refer to comment?
I should have made that clear. Under the halakha, a man who is married and has a relationship with an unmarried woman outside, as long as the woman that he's having an affair with is unmarried, he is allowed to marry her, and he's not blacklisted at all. In fact, when I was negotiating when they were talking about the regulations, Jacobi specifically said he did not want to make notation of the man. In other words, the alleged lover is not noted in the blacklist, because he said, he tripped up. He didn't want to ruin his marriage. A woman who trips up and has a relationship with a man outside of marriage is not allowed to go back to her husband. He has to divorce her. She's blacklisted. She can't remarry her husband, and she can't remarry her lover. But a man under the halakha can trip up as long as and continue with his relationship. So, in fact, the people who are really harmed from the law of the adulterous woman is the adulterous woman, and not the man. I hope that was clear enough.
Well, this is not our topic tonight, but maybe we'll have you come back and deal a bit more with it's not just about the husband being able to trip. It's also he's able to beat her a bit and not bear the consequences. and the poor woman suing for divorce will find that the rabbinic courts don't feel that this is that wrong, and it may actually be her fault. But we won't speak about that now. The next question really illustrates why these webinars and why bringing you is so important. So Rabbi Neil Gold is saying, of course, I'm familiar with the problem of Agunah in Israel, but I had no idea, if that's what you are saying, that secular women can be subjected to the same. Is that what you are saying? Secular women cannot be divorced from their husbands without his agreement. Is Agunah crisis a crisis among the non-Orthodox?
As I try to explain, yes, the answer to the question is yes, an unadulterated yes. It applies to all women. So secular women have to have their husband's agreement to get divorced. And if their husbands are vengeful or angry, or want something, and they can refuse to divorce their wives, and the wife can be an agunah in marital captivity forever until he agrees. Yes, the answer is yes.
The problem, of course, from an advocacy perspective is, yes, secular men and women are subjected to it, except they are upset, they are worked up over it when they're subjected to it. And so it's one at a time, two at a time, and therefore Susan's work, our work, is quite difficult to get people to understand that they don't have to wait until they get into that position before they understand the importance of changing the system.
I'd like to add something to that. And the issue of Mamzer is very important, because a lot of secular women might be inclined to just forget about the religious divorce and get on with their lives and with their new partners. But a lot of them don't want their children blacklisted. And so actually the whole rule of Mamzer really catches that secular woman who might tend to thumb her nose at the religious rules. So the state has the secular woman in a vise.
Now, a question that's important to our overseas audience. If you move to Israel and are already married, who has jurisdiction over your divorce?
I don't know. I'm a case in point, right? I got married in America in an Orthodox ceremony. That doesn't really matter. What matters is that I got married to a Jew. And once I moved to Israel, the rabbinic courts have jurisdiction over me. They're the only ones that can decide issues of marriage and divorce of Israeli citizens. And if I wanted to divorce my husband or he wanted to divorce me, we would have to appear in the rabbinic courts. If we agreed, there would be no problem. We could get divorced. In fact, I had clients that every time they got angry at each other and had a fight, would get divorced, and then they remarried and got divorced and remarried and divorced. It's very easy if you agree. It's not easy if you don't agree. I hope that was clear enough also.
Now, there is an interesting perspective here from an Italian law graduate. I wrote my dissertation in law, I'm a law graduate in Italy, on religious and legal pluralism. The millet system exists, though with some differences, in Greece as well. I wonder how, in terms of the judicial policy, the Supreme Court and the secular judicial system sees that, given the fact that, except from Greece, no Western democracy has anything like it.
I don't know how the millet system works in Greece. I know India has the millet system to some extent. Egypt has the millet system to some extent. But I think most of these places with the millet system, you can opt out of it. And you can decide to get married in a secular manner. I'm not an expert in Greece. In Israel, you can't opt out. it's really coercive. The state requires you to get married in an Orthodox manner and requires you to get divorced in an Orthodox manner if you're Jewish, the millet system. But there is one little interesting point that I think that I researched once, and apparently during the British Mandate, you could also opt out here in Israel. And I'm not 100% sure why they closed that hole of opting out of the millet system. In other words, religious pluralism should also allow someone to get married and, in a secular manner. And so you could opt out during the British Mandate period. I think the hole closed at some point because there were some men who were taking advantage of opting out so as not to give their wives a get. And I'm not 100% sure of how that worked historically, but I hope I answered that question too.
Well, there's a lot to be said about that, but we'll leave it for another occasion. I'm skipping a few comments, but the next question is, when you say that the Bible, I think you said Bible, there wasn't any reference to converts except to welcoming strangers because we were strangers. What about the story of Ruth related to conversion? And could the state of Israel function on converts and conversion?
Well, the book of Ruth, yeah, that's true. I guess I was looking at the 5 books of Moses as the Bible, not the story of Ruth. The story of Ruth is a lovely story. I think that's how we should embrace our converts. If someone says they're part of the Jewish people, come on in. That's my bias, but
Well, but of course, the other perspective is that as nice as your God is my God, and wherever you go, I will go, etc. Your people are my people, with all the beauty of it and the reference to it as done in the process of conversion. There's, of course, no reference to conversion in the book of Ruth. And I think historians would find it difficult to equate the inclusion of Ruth by process of immersion into the Jewish people and the Jewish faith as a formal process of conversion.
I would just refer back to that one slide that I have with these 4 academics who really delve into it quite wonderfully. If you like, I will send that to you.
Well, I know that we have Professor Aviva Zornberg on the call. So if Professor Zornberg, you want to comment on Ruth as a convert, I'm sure we'll all be benefiting from that. So just indicate that if you're willing to say a word about it. Professor Shulamit Magnus is asking, wouldn't all this end if people stopped going to the Rabbanut for marriage or divorce? Just ignore them. Going to them empowers them, and that comes from us, authorizing them by going to them.
Well, I think that everyone should be, I think that people want to be want to be equal citizens, want to be treated equally. They want to get married. They want the state to recognize them as full members of the Israeli polity. And it's not so easy to just ignore them. And so I think we have to demand change and tikkun olam. And that's why I'm very happy that Uri let me have this opportunity to speak to everybody, because I think as our consciousness is raised, more and more people will understand what's happening, and hopefully will join us on our journey of tikkun olam.
Do Israelis still go to Cyprus in order to get civil court rulings on family matters? And are these rulings recognized in Israel for purposes of inheritance, ownership of assets, etc.? So
okay.
I think that there's a bit of confusion here.
You can only go to Cyprus to get married. You can't go to Cyprus for anything else. Cyprus will not take jurisdiction over custody, children, or anything else. If you have, or if you're divorced. The only place that will deal with the divorce is your place of residence. So Israelis go to get married, and then when they come back and they want to get divorced, if they're two Jews, even if they only married in a secular ceremony in Cyprus, they have to come back and get divorced in Israel. So they're subject to the rabbinic courts.
Rabbi Rachel Yurovitz, board member of our Ruach Chidush, Rabbis and Candidates for Religious Freedom and Equality, is asking, is a marrying outside of Israel between people the rabbinic court has declared cannot marry a way around these challenges? Not suggesting this is a positive action. So if the rabbinic court rules that you cannot get married, is going outside of Israel to marry a way around this?
To some extent, but as we see now, as all of us sitting here in our houses during COVID, it's not a perfect solution in any way. No, yeah, we can't go and hop over to Cyprus to get married so easily. And the state should be the same way America has recognized that same-sex person should be allowed to marry. Israel should allow people to marry the people that they love. Obama said love is love, and they shouldn't have to go to Cyprus to get married. To some extent, it's a walk around. But what happens if, for example, a Mamzer gets married in Cyprus and then comes back here and their child becomes religious and then wants to get married? It's not the perfect solution. It's a walk around to some extent. Do you agree, Uri?
Well, I think it raises many problems that those who marry civilly outside of Israel are not always aware of. Both the issues of status and the issue of divorce, if there is no agreement between the parties, can become complicated, and there are some other issues. But yes, there are thousands of Israeli couples who either cannot marry in the rabbinate or don't want to marry in the rabbinate, who go overseas. Cyprus, Prague, Tuscany, lots of places benefit from Israelis not being able to marry. So next one, what if someone like your client was married by an Orthodox rabbi in an Orthodox ceremony in the US or elsewhere outside of Israel? What is the relevance?
Well, I'm the example, right? I got married in an Orthodox ceremony. I got married, I think the rabbi who married us actually is on the list of recognized rabbis. So if my children wanted to get married through the Rabbanut, that might help them overcome the Jewish roots regulations, which state that all immigrants have to prove that they're Jewish. So that might help me. It helped my children if they wanted to get married through the Rabbanut. So far, none of them have. So.
Well, what you implied, you said, is you think the rabbi who married you is on the list. I think that might not have come across very clearly. The rabbinate in Israel doesn't recognize all Orthodox rabbis from overseas. As a matter of fact, there are lots of them they don't recognize. And you may recall that they didn't recognize another convert, female convert, that was converted by Rabbi Haskell Luxstein. And the poor young woman had to reconvert in Jerusalem before the Rabbinic Court of Appeal because they didn't recognize Rabbi Haskell Luxstein. And the same really goes for marriage as well. They may not recognize the marriage done by certain Orthodox rabbis. And there has been an attempt in Israel to challenge the rabbinate by going to rabbis who are Orthodox rabbis, actually rabbis, professors, people of tremendous knowledge, around the back of the rabbinate, and then ask for retroactive recognition of that marriage. And sure enough, not that long ago, the Rabbinic Court in Jerusalem refused to recognize the validity of a marriage done by an Orthodox rabbi whose knowledge of marriage laws and halakha in general really cannot be disputed.
Right.
Next question. What if someone like your client, oh, sorry, So Peter Buxbaum is asking, is that the case if they did not marry in the rabbinate? I'm not sure what you're referring to, Peter, but you say you reacted to a couple of things. You said they could go to Cyprus, and like when I was a mayor, I could marry people but not divorce them. All right. Yes, Peter, you are right.
I think you answered the question. She's already answered my questions. Thank you.
Right. Okay. So Malka is asking, in Israel, or saying, in Israel, Jews can only get married or divorced through the Beit Din, the author's Beit Din.
That's not a question. Sorry.
All right, comment. Well, you made a few comments. We'll read out a loud one.
Are they wrong? I don't know. I correct me if I'm wrong, because I don't want to put these.
Okay. So the Beit Din, the author's Beit Din, marriages and divorces performed outside of the state of Israel are not questioned. Therefore, secular Jews and possibly some religious Jews go abroad to marry. Divorce is more problematic since the couple is highly unlikely going to go abroad to do so. Couples can file for division of property and custody of children in family courts, secular family courts, but the actual divorce is only through the Beit Din. Well, you know, your comment, not question, can really give rise to a whole new lecture. Every sentence in your comment really is open to a legal elaboration, because none of that is straightforward. We'll leave it for now, unless you want to make a comment, Susan, about this.
No, that's okay. Should I continue just with my bonus material and my wrap up?
Yes, but just 1 second. Let's see. All right. So just Alan Warshaw again, and that's the last one. Is it worth mentioning the conservative rabbi who was arrested for conducting a marriage, and what was significant what was the significance of that situation? All right, I happen to.
No, I'd like to say something about that. I actually wrote a piece. I wrote a piece in the Times of Israel about that. The reason I like that case, right, is because it shows the violence of the courts. In other words, I really think that Max Weber was right when he said that the state is the organ of legitimated violence. In other words, the court has such power behind it that it can act violently. It could take a rabbi out of his house in the early mornings and with the police and bring him into court to cross-examine him. Now, they let him go, and I don't think they're going to do that again. But that, for me, that's what that case exemplified. The fact that the rabbinic courts have this power and they use it and abuse it without due process, without considering basic rights of privacy and dignity, and without even having that as part of their vocabulary. So that's what that case meant to me.
Well, I happen to actually represent him in my legal hat, and there is a lot more to it even than what you suggested, but that will take another opportunity. Go ahead and give your bonus. And
here's my bonus material. What I did in the article that I wrote was I tried to understand why the Supreme Court isn't doing anything. And one of the arguments that I make is that I quote from a sociologist named Jeffrey Alexander, who talks about the power of discourse and the power of language. And what the rabbinic courts have succeeded in doing is using what I call polluting language to make the situation seem very black and white. And one example that I brought here for you is a statement that Rav Shimon Jacobi made in the case that I quote down here, it was a case that I did not bring you, which was a case to throw out all the blacklist. And what he does is he quotes from Kedushin, from the Talmud. And I'll read it to you and then I'll tell you how I understand it. One must remember that the matter of persons disqualified from marrying is referred to already in the Talmud, as it is written, Ezra left Babylon like a clean, fine, sifted flour, since all the dregs immigrated with him to Israel. But he knew whom to marry and whom not to marry because of genealogical records or lineage records. In other words, he referred to all those people on the blacklist as dregs. Without hesitation, by quoting, and he also shows that the blacklist has a very, very long lineage. It goes back to Ezra. So it's very, very hard to combat this primordial and ancient lineage, as well as the language, these polluting language, like comparing the people on the blacklist to dregs that should not be married. And then again, I just wanted to reiterate that my thesis here, which is that I'm accusing the Supreme Court because the Supreme Court could have done strict scrutiny on all these cases. And in almost all these cases, it could have said that the rabbinic courts had no jurisdiction. It could have said that the rabbinic courts have no jurisdiction over children. Anytime a child comes before it who is suspected of Mamzer, they should not deal with it at all. They could have said that there's no law in the state of Israel giving the rabbinic courts the authority over conversion at all, and certainly not only over revoking conversion. And besides, if you want to go back to the Talmud, there's no such thing as revoking conversions. It could have said in the cases of the suspected adulteresses that if there that a husband's suspicion that a wife had adultery is not reason, is not probable cause. And it could have said that they're not going to even hear that issue if it's not relevant to a contested divorce. And with respect to Jewish roots, they can also say that if someone comes before them and says that they're Jewish, they're presumed Jewish, and the burden is on the state to prove that they're not. So there's lots of things here that the Supreme Court could have, should have, I wish they would do. And I also try and analyze why they don't, but that's where I'm pointing my finger at. Because really, I think the rabbinic courts should be entitled to interpret the halakha as they see fit. The problem here is that the state is incorporating the halakha and coercing this particular interpretation of halakha on its citizens in direct violation of basic rights to marry, basic rights to religious freedom, to freedom of conscience, to privacy, and to dignity. And and then I'll just end with a little bit about the Center for Women's Justice. So we want to defend women's rights to equality, dignity, and justice whenever they are compromised by state religious institutions. We try to set legal precedents, ensure transparency and due process, educate towards critical awareness of civil liberties infringements by the Israeli government, and change policies to allow women full civil liberties while still being a Jewish and democratic state. That's what we try to do. And finally, I'm going to thank all of our supporters. I hope we have almost everybody here, but the Center for Women's Justice is supported by various women's organizations in the United States. If any of you are on this webinar, I personally thank you for being there for us, because without your support, we would be able to do nothing. So thank you. And thank you again, Uri, for inviting me to this webinar. And thank you for listening. And I hope that it has been interesting.
Thank you, Susan. I'm sure that everybody has benefited. Those who know a lot about Israel and follow those issues, I think have received deeper analysis and additional information that is quite, rare among our observers overseas. And for those who were not that familiar with the challenges facing us when we deal with issues of law, religion, and state, you have given us an in-depth insight as to how challenging that is. If you were on our previous webinar when I presented the findings of the 2020 Israel Religion and State Index, you would know that Israelis are eager to have diaspora jury engage in this battle, and the invitation that Susan extended, the invitation that we extend, the vision statement on Israel as a Jewish and democratic state that we wrote together with leading Orthodox rabbi, they are all an invitation for our audience, your friends, your colleagues, to partner with us. Partner with organizations like the Center for Women's Justice and with Chidush and others to make a difference and make Israel truly pluralistic, inclusive, respectful of basic democratic values, religious freedom, and then obviously Israel will be far greater Jewish and democratic state than the situation that Susan described. Last thing, in 2 weeks, November 2nd, we have our next webinar with great speakers that follow in the footsteps of those that like Dr. Susan Weiss today. And I'm referring to Professor Rabbi Larry Hoffman and Professor Rabbi Dalia Marks, who are going to shed light on a different aspect of our work, the rabbinic, spiritual, namely, they're going to deal with the synagogue, Jewish liturgy, confronting COVID-19. So 2 weeks from now, you'll all get an invitation, and I hope you'll join us for a boost of inspiration that's connected with Judaism facing COVID-19. Thank you all. Thank you, Susan, again, and hopefully we'll see you in 2 weeks. Shalom and lehitraot.
Uri, I don't know if you have a few minutes or you got to run. Close it.
Well, I think we'll end now. Just write me.
Yeah.
Thanks. Bye.
Okay. That is on my guess.